Okay, good afternoon. My name is Allison McKenzie and I am the Chair of the Historic Conservation Board. I would like to take a minute to remind everyone about the rules of this proceeding. This proceeding is at all times governed by the rules of procedure adopted by the board on September 26, 2011, last amended on March 9, 2020. A copy of the rules of procedure is available for review in the back of the room and online. All those planning to testify today, which does not include those solely making arguments such as attorneys, should please stand now and take an oath administered by the board's attorney.
So anyone who's going to provide any testimony here today?
I should stand up.
Stand and
Assume that's us. We're the homeowners, I assume that's us.
if you plan on speaking at all.
If you're an attorney though, no, correct?
Yeah, unless you're an attorney. Yep. So if you could just raise your right hand. Do you swear or affirm that the testimony you shall provide will be the truth, the whole truth, and nothing but the truth? Yes. Thank you.
This is a quasi-judicial hearing. As such, the board reserves the right to deliberate in private. The Ohio rules of evidence do not apply to this hearing. However, professional rules of conduct do apply and candor to the tribunal is required. The board members are citizen volunteers and are not paid for their service. They are treated as public officials under Ohio law. Any attempt to influence them, including but not limited to bribery, intimidation, retaliation, which may include contacting their employer in an attempt to exert influence, is punishable as a crime. All should be aware that this meeting is being recorded. Therefore, before you begin your comments, please state your name and address for the record. With that said, let's proceed with the first item.
Thank you, Madam Chair. Item 1 today is an application for a certificate of appropriateness and zoning relief for the property at 1887 Madison Road. It's located in the East Walnut Hills Historic District. And the current application is a request for 2 accessory structures in the side yard of the property. That does require a COA as well as zoning relief. And the zoning relief is specifically related to the number, size, and placement of these accessory structures. So the zoning code allows a maximum of 2 accessory structures with a cumulative size of 800 square feet and requires them to be in the rear yard. So the 2 accessory structures in question here are the shed that is located immediately behind the building, as well as the geodesic dome greenhouse further towards the south on the property. The existing house is oriented to the north. However, its street frontage access is from Baker Place, which is on the east. So even though the house is oriented to the north, technically the front yard of the house, according to zoning, is the east side, which is why the 2 accessory structures are considered to be in the side yard and require that variance for the side yard location. There are 2 existing historic accessory structures on the site already. There is a 1920s garage and then an 1890s art studio in the corner of the property. So with the placement of the 2 additional accessory structures, it exceeds the maximum number and the maximum size of accessory structures. So that is the zoning relief that's required, 3 separate items. And then the certificate of appropriateness is also needed. So the 2 newer accessory structures consist of a garden shed that is used to store tools and gardening equipment that is directly to the rear or to the south of the house. And then also a geodesic dome that is used for agricultural uses. There's a fairly large garden plot on the rear of the lot that includes the adjacent parcel. The geodesic dome was originally placed crossing that parcel line, but because the owners of the property do not own this parcel as well, they did relocate that to be fully on their property and 3 feet off the property line, complying with that setback requirement for accessory structures. So staff feels that in general, these 2 structures are appropriate and they are not detrimental to the character of the existing building or the surrounding district, as they are placed to the south of the house, away from the main front orientation of the building. And the area is fairly heavily vegetated. So there are not substantial views from any of the surrounding streets. The sheds are not placed on permanent foundations, though they are easily reversible changes to the property that could be removed and not leave really any trace of what was there before, restoring the site to its original historic configurations. And that goes both for the agricultural dome as well as the shed structure. So staff does not feel that there are any detriments to the character from a COA standpoint. And from a zoning relief standpoint, staff also feels that these are generally appropriate. It is a fairly large lot, being over 1.5 acres. It does have a substantial gardening use on the south of the property that necessitates the agricultural structure. And then as the original outbuildings are currently used, as this was originally built as an artist studio. And then obviously the garage, there's not a lot of room left over that is for the tools and equipment that are needed for the large gardening area on the property. So staff feels that the additional sheds are appropriate and do not cause any undue adverse effects on the adjacent property owners. So with that being said, staff recommends the Historic Conservation Board take the following actions based on plans submitted with this application. Recommend approval of the locational variance for the placement of 2 accessory structures in the side yard. Recommend approval of a dimensional variance of 637 square feet for a cumulative size of accessory structures of 1,437 square feet in excess of the 800 square foot limit. And then approve a numerical variance of 2 for a total of 4 accessory structures in excess of the 2 permitted. Staff also recommends approval of a certificate of appropriateness for 1887 Madison Road, including any revisions submitted for permit subject to staff review and approval.
Okay, if representatives from the owner would like to come on up. If there's anything you would like to add for us?
Sure, I'm sorry.
Okay.
I'm Rebecca Simpson with Finney Law Firm. I represent the property owner, Jenny Ruley. She's married to Trace Curry, and they live in the property together, even though hers is the only name on the title. It's their house. Mr. Owen has done a terrific job with the report and explaining everything, so I will be very brief. My clients, because the structures were not attached to anything, did not realize that there was any sort of process that they needed to go through. And once they got a notice and found out that was true, we've been working with the city, and the city has been extremely helpful. And I thank the city and Mr. Owen for all the help sort of shepherding us through the process. Their goal really is to do whatever they need to do to make sure that the structures are approved and compliant with the Cincinnati zoning code and with the Historic Conservation Board requirements. As Mr. Owen mentioned, they have a large vegetable garden in the back, and they can't use the art studio for the equipment. They actually have a tractor that they use for the property that used to just sit outside. And so they built a shed, which is in the likeness of the art studio, to put the farming equipment or that equipment as well as the tractor inside it, and thought that would be more sightly than, a tractor sitting out. And as well, the dome is for the farming, and there really wasn't any room. It's, as old garages are usually small. And so it fits their 2 cars and really no room for the equipment. So that's why they have the 2 structures. I understand that there was some opposition to this that was sent in past the deadline, but you guys went ahead and accepted it. I would prefer, if it's okay with you, to reserve time to address that if someone speaks against it afterwards, so that I can address it, or I can address what was submitted now, if that's what you would prefer.
Whichever you prefer is fine.
I prefer to address after, please.
Okay.
Thank you.
Would your clients like to speak, or are they just here if we have questions?
They're here to answer any questions. If you guys have any questions, they'd be happy to answer.
Okay, so now would be the time if the board has any questions for the applicant or staff. We do have one person signed up from the public, but we'll address any questions first.
I didn't notice any negative response from the neighbors in the packet.
It was distributed by.
There was? Oh, I'm sorry. Okay, I didn't see.
There was one distributed by email as well.
Okay.
You guys to the.
Are there any questions?
I think I have a question. So the shed, the storage shed immediately behind the house, you just compared it to the studio. I'm not sure how anybody makes that stylistic comparison, but, yeah, that.
Yeah, I apologize if I misspoke. I just meant in the same color scheme, same rooftop. I mean, you can't make a shed look exactly like our studio, but you know, they tried to make it in sort of the
It
same.
looks like they were consulted by Home Depot or something. That's,
Yeah,
but that doesn't mean it's illegal. Well, if it's approved. Doug, the two structures that are there, they would not be in compliance. They're already there, they're existing, but they would not be in compliance, correct?
Correct. They're considered legally non-conforming. Well, they are appropriately located. I believe the size is over 800 square feet. I would have to double check that. So if the size cumulative combined is over 800 square feet of those two existing structures, then that would be legally non-conforming.
And could you explain again the relationship between the individuals that own the property just to the south of that little, like, there's no easement or anything, but she has said, you guys can build gardens here as long as you want.
and
The owners actually, it's their garden,
yes,
or
so.
they maintain it.
Yeah, Trace, do you want to explain?
Yeah, so,
Let me explain really quickly. There actually is an easement, but the easement is for ingress and egress. We did some research on that.
Okay.
But my understanding is that property owner purchased that property to prevent a development that was planned at one point, and so has historically let the owner of the house that they now live in, it's within their fence. So they have a backyard fence, and that parcel is within their backyard. So they tend to it as if it were their own property, and have actually talked to the property owner about purchasing it. So they're working that out
So
now.
that's an informal agreement now. There's no legal control over that property. By
Except for the ingress, egress.
Other than the ingress
Other
egress
than-
easement, yeah. I apologize, I asked for you and then I didn't.
That's all I have. Thank you.
So have anything incorrect there.
Thank you.
Any other questions at this point?
I do have one more question. Mr. Owen, can you explain one more time why there's going to be 4 accessory structures on the property now? What were your thoughts? Did you struggle with that decision at all? Because if you look, I'm not sure the defending attorney, you know, they were talking about the number of almost everybody's got a pool up there. So there's one, and then half the people have garages. There's 2 accessory structures, and then other people have, I think there's other little buildings up there. So I'm not sure.
So there's not a lot of room in that structure. The artist studio was never intended to be used as storage or anything along those lines. It's continuing in a similar historic use. So there's really not much space on the property. So just from a need standpoint, you know, with the large garden, there are allowances for agricultural structures in single family districts. So aside from, you know, the number and size, this would otherwise be permitted. So it seemed reasonable for the specific uses that are proposed for them, and also just due to the fact of, you know, the location seems to me to be the most appropriate location that's behind, you know, the main orientation of the house. So, I mean, this is a gorgeous contributing building. This is the view from the front. So the building, the accessory structures being located on the opposite side are not going to detract at all from the structure. Whereas if they had to be placed in the side, in the rear yard, then, you know, they could technically be put up closer to the actual driveway and be in a compliant location, but obviously be much more visible. So, so yeah, to me, this seems like a reasonable request, both from a zoning relief standpoint and a COA.
And the shed, and I'm sorry, the shed would need a building permit.
That I'm not entirely sure of. That's,
Or that doesn't matter?
I mean, not for the relief that they're requesting today. If it needs a building permit, then they would need to follow up with a separate submission for that. But you know, the location would not theoretically change, so that wouldn't affect today's decision. But yeah, I can clarify with buildings and inspections after the hearing if this would need to come through for a building permit.
We do have one other person signed up, Kenneth Kreider, maybe? Would you like to speak?
Yes.
What would you like to tell us?
Well, first I'll state my name for the record, Kenneth P. Kreider of Keating, Michigan, and Cleat Camp, and I represent the property owner at 1875 Keys Crescent, which is Rufus B. LLC, an Ohio Limited Liability Company. I did submit a letter last week. I understand it was after the deadline, but it was the day that I received the staff report. So from a procedural standpoint, I don't know how a party that is going to oppose something can fully express their opposition before they read the staff report and seen the full packet. So I submitted it as soon as the packet was available. And I understand the chair allowed that, so I appreciate that. I do have 2 additional photographs in addition to the 3 that were submitted. And I have copies of those and I can distribute those because I'll refer to those during my comments. I'll just keep one. Sure. Okay. Now, there may be 6 or 7 more, so we should be okay. So first, a general statement, and I alluded to this in the letter. I'm familiar with the East Walnut Hills Historic District. I've lived there for 25 years. And in addition, I was on this board and heard numerous cases brought before this board when I was on the board. And I did not just rely on memory and experience, but I also looked at cages. There really aren't that many properties with 2 accessory structures. Some houses have pools, maybe south side of Madison, not many on the north side of Madison. The district goes all the way up by the tennis club and all the way down to the end of southern end of Pineview. So district is fairly large in that respect. But many houses in East Walnut Hills don't even have garages. Most of the neighborhood was built during the streetcar era. So I think the staff identified the garage as being built in the 1920s. That makes sense. The artist studio is older, probably not as old as the principal structure, but it's been there. And it was there when the district was designated. So no issue whatsoever with those, or the fact that there are 2, or the fact that they may even exceed the zoning maximum size for accessories, because of course they've been there, they're legal non-conforming, and they were there when the district was designated. But anything else to be maintained has to first meet the criteria for a certificate of appropriateness, as you know. And then in this case, because there would be more than 2, we have 3 zoning variances that we need to overcome. Now, the opponent takes no issue with the location. The side yard is the only reasonable location for any of these outbuildings. The rear yard, the legal rear yard would be even closer to 1875 Keys Crescent. The front yard would be completely inappropriate place to put these out towards Baker, or the other side yard towards Madison, which is the nominal front yard. In any case, the standards for certificate of appropriateness for new construction, and I suppose that'd be the only way to look at this. They state the materials that are synthetic in appearance or that are highly reflective are generally inappropriate. Application of these guidelines is somewhat problematic, as I said, because I'm not sure this is new construction. Really, the shed looks to be a prefab, and the dome is sort of, temporary. But in any case, the 3 questions to ask. Do these appear compatible with the main house circa 1855? The answer is patently not. They are completely inappropriate when compared to the main house. No aesthetic. They don't do anything to add to the aesthetics of the main house. Second question, are the materials natural or synthetic? In the case of the dome, clearly synthetic. I'm going to refer to the fourth photograph. This is the one of the shed, the prefab shed. If you look closely, you can see that it's a synthetic type wood grain applied as the siding material. The roof appears to be metal, so that would be appropriate. And the window looks to be a vinyl window, the window in the side and in the front doors, which I think are in the staff. So the answer there is no. Finally, is the massing and scale compatible or even comparable to the existing structures? And once again, the only reasonable answer is in the negative. So neither one of these already existing, unpermitted structures is entitled to a certificate of appropriateness based on those standards. Now, putting that aside for a minute, let's talk about the zoning variances. As I said, this is the only reasonable location for these in this side yard, but the number of accessory structures we talked about a minute ago, 4 is twice the number that is permitted by code. And the size is almost twice the square footage permitted by code. Now, why does the code put limits on these things? Well, in general, it puts limits on these things because normally you don't want to take in a single family SF20 residential district. You don't want an open space district of low density to start to become cluttered. And I would submit that this is becoming very cluttered, and for that reason, shouldn't receive either of those two variances. The code gives us two different standards for allowing a variance above 2 accessory structures in the SF20 district. First, that the variance is necessary or appropriate in the interest of historic conservation so as not to adversely affect the historic, architectural, or aesthetic integrity of the historic district. Now, if the proposal is to allow buildings or structures or temporary, whatever they are, that are already there to remain, if that isn't entitled to a certificate of appropriateness if it was proposed as new construction, then there's no way that it can satisfy that variance standard. The only other variance standard to apply is whether denial would be a denial of any economically viable use of the property. And clearly that's not the case because they already live there. They already have all the benefits that anyone else in the East Walnut Hills Historic District enjoys. It has a garage, it has another outbuilding, and it has a swimming pool. And I will refer you to this picture, which is the artist studio built, around 1890 or what have you. If you look at the bottom of the photo, you'll see there's a door. So there is storage space there. And of course, there's a garage. So if one decided they needed a tractor, they could keep the tractor in the garage and park the cars outside like many other people in East Walnut Hills must do. Or you could enlarge the garage. You could get a certificate of appropriateness and actually add to the garage in an aesthetic way. But none of those things were done. Instead, 2 structures were put up without any permits, without a certificate of appropriateness. And now you're being asked to approve those after the fact. So I would say applying some of the other standards that are discussed in the staff report, let's go through those. Zoning, whether the 4 accessories would conform to the underlying zoning district regulations. Well, not without a variance, they won't, so that doesn't apply. Whether the proposal is compatible. We talked about compatibility. I went through the standards with you a few moments ago. Neighborhood compatibility. No other property has 3 or 4, or including the pool, 5 accessory structures, regardless of their size. I just say to staff, if you take a look and you use cages, you will not find any other property in East Walnut Hills that is residential that has that number of accessories. Finally, adverse effects. Allowing an after the fact approval by variance is, in my opinion, likely to encourage other property owners to seek to clutter their properties with non-historic or prefab buildings and ask for permission after the fact. It's degrading the aspirational nature of the guidelines in the first place. It's insulting to existing property owners, and therefore the board should not support a variance in these situations. If this came to the board before it was done, the board would turn it down. I'm quite confident of that. So to now allow it after the fact, there's no justification for that either. Finally, public benefits. There are no public benefits derived from allowing this. possibly with the exception of allowing a vegetable garden, but a vegetable garden could still exist with or without these structures. So I think that's kind of a red herring. I think a failure to maintain the aesthetics in an historic district with a lot of high value investment in property like East Walnut Hills is a detriment to the general welfare when it's looked at in that context. Permissiveness leads to disinvestment. Disinvestment lowers property values for all concerned. And before you know it, you don't have an historic district anymore. So for these reasons, I respectfully ask the board to deny the C of A and the zoning variances.
Mr. Owen, can you provide the definition for accessory structure? I can see where, the perception would be, oh, these are temporary. I just want to make sure my recollection of the accessory structure definition is.
Yes, 1 second. Zoning code defines an accessory structure as a structure other than a sign exclusively associated with a specific principal structure located more than 1 foot from the principal structure.
Is a light pole accessory structure?
Technically, I guess it would be, however, there are certain structures that are exempted from the zoning code requirements, including things like lampposts and flagpoles, bird baths, things along those lines.
And a deck or patio that's not attached to the building would be accessory, but if it's attached, it's not because it doesn't meet the 1 foot.
Correct, and it's part of the principal structure.
Trying to get the full understanding of who has what accessory structures. Are there any questions for Mr. Kreider before I bring up Ms. Simpson?
I would state my opinion at this point. That shed right behind the house is ugly as hell. And I don't see how that's in context with the neighborhood. The geodesic dome, I'm sorry, I have 6 years of architectural brainwashing, so I feel a little different about geodesic domes than maybe the average person on the street. I'm less inclined to vote that, but I think all of a sudden they have 4 accessory structures, and I think I agree with the defendant or plaintiff, I don't know, that it doesn't have, I mean, I think that is vinyl siding on that shed. And that's not an appropriate use. Now, in Over the Rhine, have we even allowed that on the back of buildings? I don't think we have.
Vinyl, no.
And vinyl windows aren't specifically excluded from this historic district, right? You're just relying on the standard set in the other historic districts.
Right, I don't believe this district specifically prohibits vinyl windows. I mean, it's similar to, the other historic districts that, imply that vinyl windows should not be installed. However, I think on a small accessory structure like this, I'm not sure how strict we have been on previous projects for that type of installation.
I must admit, I am bothered by the fact that the structures went up before before they were approved. And I'm gonna agree with Mr. Delasco about the aesthetics of the shed. I just don't think it fits. Even though the color scheme is the same as the artist studio, it's not appropriate material. And I do have a question about the artist studio. Is it used, the artist studio? I mean,
It's-
studio. So they spent $300,000 restoring it, and now it's used as a guest house. But it would not have been appropriate to park a tractor in. I don't think you could have even gotten a tractor in it.
Elevated Steps going up.
It's elevated. And that would have, I mean, it's historical, a famous artist from Cincinnati, so it's not something that you would want to destroy. I'm making it into a shed. I apologize, I started addressing.
Please add what you would like to add now.
Sure thing. And my clients certainly did not understand that they needed to come before you before they put these structures on their property. I mean, to be very honest, when I read the zoning code, because they weren't attached, I didn't think they qualified as accessory buildings. But I spoke with Mr. Owen and he explained to me that they did. And so they're trying to go through the process now and fix it. But there was no ill intent on their part. They were not trying to get anything past anyone. They truly just didn't understand that they needed to go through the process. And now that they do, they're happy to go through the process and do whatever they need to make this, fit within your requirements. I don't want to be redundant. I don't want to repeat what Mr. Owen already talked about. He already addressed the various, and it's in his report, the various different requirements for these types of variances and explained why these do satisfy that. I do understand that there are some concerns on the board with respect to the materials that they're made out of. They are removable structures, and I will just point out that, I know Mr. Kreider spoke about looking at cages and seeing if there are other properties that have this many accessory structures. And I will admit, I did not do that search on cages to see if there were. However, on cages, as you know, sometimes it's difficult to see because of trees and things like that, whether there are accessory structures. And not only that, I don't know how many, and there was not an apples to apples comparison because this is a large piece of property. And many of the properties in East Walnut Hills are not as large. And when you consider the fact that the parcel that they don't own is inside their fence and they have the entire time they've lived there and the owners before them the entire time they lived there took care of that property, it's closer to 2 acres that they have that they take care of. So they really do need the tractor. So on such a large parcel, 4 accessory buildings are not cluttering. And not only that, you can't, as Mr. Owen pointed out, it's a beautiful front yard. You can't see any of these accessory buildings. Well, you can't see the 2 that at issue. Maybe, I don't know if you can see the artistry or not, but you can't see the 2 accessory buildings at issue from the front of the house at all. And there's tree cover around the house. And my understanding from speaking with my clients is that even the photos that were submitted were not taken from his client's property. They were actually taken from another neighbor's property. Further, my client, their neighbors submitted 2 letters in support. They also went and talked to their neighbors on Baker Street, who are the ones that would have the best view into what they consider their backyard. I understand it's technically a side yard, and those neighbors didn't have objections. So, I mean, considering the fact that, as Mr. Owen says, it's consistent with the historical district, they are necessary for the large piece of property in order to have the farming equipment or the equipment that they need to take care of and tend their property, and for the geodesic dome to continue their growing season through the spring and winter and fall. And you can't see it. We would ask, please, that the variances be approved as the city has recommended.
Questions or comments from the board?
Mr. Owen, I would like to ask you a question. We heard your comments, okay? What was your thinking on this? Why did you allow the variance?
I mean, just as I explained, I think they were reasonable variances, both for the size, number, and placement, just because of the size of the property for one thing. I mean, you can have 2 accessory structures, 800 square feet on an SF20 property that's over 20,000 square feet, but also on an SF2, which is only 2,000 square feet. So I don't think the cluttering is necessarily an issue. And with the historic nature of the existing outbuildings and the alterations that would be needed to those in order to incorporate the new structures in those functions into the existing outbuildings, I felt that this was the better option.
I guess my problem isn't so much that there's additional structures going up, but the structures. I mean, that, I would say that probably should not be in a historic district. I don't know about a geodesic dome or not, but I know that district and spent some time back there, and I guess if I was a neighbor, I wouldn't want that up.
I guess I am also in the position that I think that this property is probably large enough that 4 accessory structures is maybe something that's worth considering, but I do also tend to agree that if we saw this shed come before us in the normal approval process,
Wouldn't happen.
and it's unfortunate that we're not in a normal approval process, because it does make us try to consider things differently, but I'm not sure if we should.
Yeah, I'd like to say, could just redesign the shed and come back, but I'm not sure I could guarantee that I'd vote to allow the additional structures if you did come back. If we'd have seen it the first time, I think you'd had a better shot with my vote. If we'd had an opportunity to rule on the appearance or the compliance with the certificate of appropriateness. I don't think it's in compliance with that. And I agree with the other board members. I'm less concerned about multiple, in this case, less concerned about extra structures than I am appropriateness of them. The only thing I would offer is, if you spent so much money on the studio, you could have spent a little bit more on the, I'm not sure throwing money at the shed is necessarily going to get in compliance, but a redesign definitely could. But again, if you came back with it, I'm not sure what my vote would be.
I mean, Doug, what happens if we say, no certificate of appropriateness, things there?
If it's denied by the board today, they could submit a new application with a different design. They can't submit with the same plans, but they could submit a new application with a different design. If it goes through the full vote and it's denied, they would have to start over at the beginning with a new application and another 2-month process. Otherwise, if it's tabled by the board today, they could revise the design of the shed and come back when those plans are ready.
I just don't even know if that's a feasible path forward. I assume that a denial, though, does give them the opportunity to appeal if that is a desired path.
Correct.
Is tabling something that your client is at all interested in?
Could I have a minute to confer with my client, please? Thank you.
This is already built. There's the sun. Let's be tabled for. Because, yeah.
Do you have a recommendation?
I don't, just because I don't know how long the design process ordinarily takes, or how long it would take a professional to do that kind of work. So it's appropriate. Based on those considerations, just a decent amount of time.
Did they say the studio was vacant?
Guest house.
They did not say
The guest house.
that.
Thank you so much for asking that question. My clients would please like to table the discussion and come back with plans for the shed.
Okay, is there a period of time that they would like us to consider for the tabling?
How long will it take to get plans for the shed? 30 days?
I would think more like 60.
60 days? 60 days, please?
Would you like to make a motion? Someone?
Madam Chair, I propose that we table the item under discussion for 60 days.
Second.
Okay, I'll call the roll. Mr. Zalasko?
Aye.
Mr. Dobbins?
Aye.
Mr. Sunderman?
Aye.
Chair votes aye. Good luck.
Thank you.
I know that's not what you wanted to hear. Hopefully we'll come back with something that can make everyone happy.
All right, thank you so much.
Okay, we do have hearing schedule as additional business. Do we need to act on this or is this informational? Can I get a motion concerning the 2025 hearing?
Madam Chair, I'd like to make a motion that we approve the dates for the 2025 meetings of the Historic Conservation Board.
Second.
Mr. Zalasko?
Aye.
Mr. Dobbins?
Aye.
Chair votes aye. Is there anything additional for today? Okay, with that, I will entertain a motion for adjournment.
So moved. He did.
Who's doing the second then?
Second.